decision could still come at any time, but now we know a grand jury has a deadline of January 7th to decide whether Officer Darren Wilson will be charged in the shooting death of Michael Brown. I can tell you that a circuit judge has decided to give the grand jury the extra time. The grand jury is meeting weekly and now only hearing evidence in the Brown case.
We are finally hearing pieces of what the grand jury is debating in the Ferguson, Missouri shooting. A 10-year-old is also facing murder charges in another case. And another case, one of the Ebola-infected nurses is getting legal assistance. Let's find out why. Pleasure to welcome into MidPoint our latest contributor, a veteran litigator in Philadelphia County and the federal courts, a volunteer child advocate, and our legal expert, Heather Hansen, joins us from New York. Heather, pleasure to have you on board. Thanks for joining us.
Ed, it's my pleasure to be here.
Let's go ahead and get started right away. We got a lot to cover here. Ferguson, Missouri, the grand jury is now hearing what the officer saw and what the officer is reporting. This came out in the New York Times on Sunday, and it seems to be that Darren Wilson's account is pretty much along the lines of what he said it was, but it is now basically saying that some of the eyewitness accounts are incorrect. Again, this is all grand jury, but it's still a little unique to have this slip out, isn't it, at this point of a grand jury hearing, and to be able to start talking about it like this, and this is going to lead to a lot of people with a lot of very, very hard feelings.
It's very unique, Ed, and you said it well when you introduced this piece. We're getting bits and pieces of what the grand jury is hearing. The problem with that is that the public is now making assumptions and trying to come to conclusions based on just those bits and pieces. The grand jury is hearing a whole lot more than what we've heard in that New York Times article or in what was brought out today. And it's on all of that evidence that they're going to have to make their decision of whether or not to indict.
But it does tell us once again, and this is a subject that we've covered here an awful lot. We talk about what eyewitnesses say, positive, negative, whatever. You always have to take that with a grain of salt in so many ways because emotions are involved and you still need to get the forensic evidence. You can't simply rely all the time on what a witness reports, correct?
Not only that, but most of the time the witnesses are going to differ. There's an effect of when you hear things, when you see things, and we see that over and over again in all kinds of cases. So witness accounts are usually one of the less reliable types of evidence. The more reliable types of evidence are the forensic evidence, the gunshot residue, the blood, the various parts of the body that were hit by guns. That's the evidence that, if supported by the witnesses, will be telling in this case. The witnesses ultimately, as you said, in many ways, they've negated one another to such an extent that you might want to throw them all out.
All right, let's go ahead and move to Texas now. The Supreme Court has cleared the way for the Texas voter ID law. Let's see. 1 week we need them. The next week we don't. The next week we do. The next week we don't. It is, if there was ever anything that may be so confusing to voters in any state, it is the voter ID law because it simply doesn't stand still, correct?
That's absolutely correct. And the reality is here, the Supreme Court hasn't ruled on the constitutionality of the law. They haven't ruled on the substance. They've simply said that for this year, that law is going to stay in effect. Many say that it's because of exactly what you just said. They want it to be consistent. That law has been in effect for a couple of years. It's what people expect when they go to the voting polls, and so they want to keep it that way for this year. But rest assured, the Supreme Court will be hearing the substance of that case in the future.
All right, let's go ahead and get to the another one of the cases that I talked about earlier. This just astounded me. A 10-year-old boy who will be tried as an adult for murder. How did this happen?
Well, it's in Pennsylvania. Pennsylvania, Ed, is one of 3 states that allows children as young as 10 to be tried in adult courts. And here they have found that this child is going to be tried. They have put forward that the child's going to be tried in adult courts. His lawyer is going to file for a competency hearing to say that he's not competent to be tried as an adult, that he may not be mentally competent to be tried at all. But it is an unusual thing to have a child that young, and something that I don't necessarily agree with, to have a child that young be tried in an adult court as opposed to the juvenile system.
Isn't it fair to say that a 10-year-old kid, and again, we're talking about average here, simply does not have the ability to be able to reason certain things, and whether or not to murder someone, that's a huge stretch legally, isn't it?
A huge stretch. And there's scientific evidence that the prefrontal cortex is just not developed to such a degree that certain decisions can be made in such a way that children understand them. You know, don't allow children to enlist in the military. We don't allow them to vote. We don't allow them to drink. We don't allow them to smoke. But the thought that we can now put this child, a 10-year-old child, in jail for the rest of his life because of this crime is a little bit hard to swallow.
Would you expect, and again, I know we're just opining here, and this still has to basically play itself out, but would you expect that this young man is not going to spend the rest of his life in jail, that this will get worked out some way or another?
Yeah, and the Supreme Court has tried to roll back a little bit on that and not make it so that children can spend the rest of their lives in court. I think this child ultimately, hopefully, will be found incompetent to try the case as an adult, and some sort of plea deal will be made.
All right, next up, Arizona courts ruling that illegal immigrants are entitled to bail. This goes back to 2006, and this has been bounced back and forth for so many years here. Where does this law stand right now, and what exactly does it mean?
It is illegal to say that illegal immigrants cannot get bail, which is what Proposition 100 in Arizona did. The court found that you are taking away the illegal immigrants' substantive due process rights, which they are entitled to despite the fact that they're illegal immigrants, and that there's no compelling interest to make that something that the courts are able to do. So here, had the Arizona state been able to prove that illegal immigrants were more likely to jump bail, more likely to abscond, more likely to commit other crimes, the court may have ruled another way. But they just did not have that evidence in front of them, and therefore had to find that this law was unconstitutional.
All right, about a minute or so that we have left, and I've been following this too. The Sayreville teenagers, the football team, basically involved in sexual assault and rape cases here. They may be tried also as adults. They're going to figure it out in the next 30 days. Personally, I think the parents and the teachers and the coaches are the ones who should also be held responsible for a lot of this. This is just reprehensible. Where do you see this going?
Ed, you know, we may see that. We've seen some of the coaches being suspended, and depending on, it's similar to the rape case in Ohio that we saw some years ago with regards to some Ohio football players who were raping a young girl. Here, we may actually see some responsibility on behalf of the adults involved. For the teenagers, I think that the possibility of being tried as adults will lead to some plea deals. In addition, the fact that they may have differing stories may lead to some plea deals. Ultimately, I'd be surprised if any of these cases actually try. And
stop calling it hazing. It's sexual assault, right?
That's right. Absolutely. I mean, calling this bullying and calling this hazing is really taking something making it far less important than what it actually was.
Absolutely. Heather Hansen, a pleasure to have you on board the show. We'll be turning to you for a lot of our legalese as well. I thank you. We'll talk real soon.
Thanks, Ed.
All right, Heather. Later on this hour, revealing one of the most dangerous companies seeking to ply you with so-called cures for Ebola. And after the break, why IBM is not computing well on Wall Street this day. That and so much more coming up here on MidPoint.